Let's continue this discussion on the proposed amendments on the ballot, focusing on the judicial appointments. And joining us are former North Carolina governors, Republican Jim Martin, Democrat Mike Easley. Gentlemen, thank you so much.
Nice of you to invite us. Thank you.
Nice of you to be here. Yeah. Well, a Democrat and a Republican sitting here, both on the same side of this issue of a judicial appointments amendment, and you both say no to it. Why?
Well, it is unusual. It's historically rare to have governors get together for a political cause like this that is not partisan in its nature. I got a call from Governor McCrory when these two amendments were passed, and he said, we got to do something about this. Then I got a call from Governor Hunt. He says, we got to do something about this. So I called Mike and Beverly Perdue, and they said, we're in. And so we've got all 5 living governors, 3 Democrats, 2 Republicans, all of us firmly against these last 2 amendments on the ballot that have to do with taking appointive power from the governor and giving it to the General Assembly.
Governor Easley, tell me about sitting as a governor. You have a lot of power, and you always have legislators at times who are chipping away to make more power for themselves and I guess put governors in their place according to them. What is that balance like? You were in the first part of this century. What's it like balancing your weight against legislative might?
Well, you have to work with the legislature. It's institutional tensions. The Senate doesn't like the House sometimes. The House doesn't like the Senate. And the only thing they can agree on is they don't like the governor more than they don't like each other. And so they generally want to do the right thing, and they'll generally do what you ask them to do. Just sometimes you can't think of enough stuff to tell them not to do. And this amendment is one of them that Governor Martin just mentioned. This has to do with the legislature wanting to control much more than just the governor's powers. They want to control the judiciary.
The courts. Yeah.
The courts. And there's been some tension between the legislature and the courts over the last few years because this legislature has passed a lot of legislation that the courts have rejected as unconstitutional. Consequently, I think they feel some need to have more control of the judiciary. That's not a good idea because we're supposed to be co-equal branches. The judiciary has to be independent, just like the governor does and the legislature does.
One of the factors here is that the North Carolina Constitution clearly gives the power to the governor to appoint a judge when there's a vacancy. And then at the next election, they stand for election to hold that particular spot. But the governor has that appointment power. And what you do is you get recommendations from all over. You get the approval of the Bar Association for those that are serious candidates, and then you make the best choice you can. In my case, I've tended to favor Republicans for a court because I was a Republican and Republicans hadn't been appointed before, and I thought we ought to have at least a chance for them to do that, but not always. I would get input from a lot of directions. Now, what this particular amendment would do, they don't want to repeal the governor having the appointive power because that would be a direct assault on the Constitution. So what they're proposing to do is say, no, you don't get your recommendations from everyone. Your recommendations will come only from the General Assembly. And the General Assembly will get together, particularly the majority party of the General Assembly will make the decision, the leadership of the majority party, whichever it is, and they will submit 2 names for the governor to consider, and the governor has to appoint one of those 2. But, and he can't veto that and make them start over. But there's a catch in there that's not mentioned in the literature about the matter that's on the referendum for voters to look at, and that is that if the governor doesn't get that appointment made in 10 days, the General Assembly will take that and make the appointment. Now, that in effect takes the power of appointment away because it doesn't allow the governor time to vet these 2 candidates. But what if he doesn't? What if the governor decides that they've got some questionable problems in their background and doesn't want to appoint either one of them? Then the General Assembly, after 10 days, will appoint one to their satisfaction. And I say that's wrong. That's violating the separation of powers. In the Constitution, it says that the powers of the executive, that's the governor, the legislative, that's the General Assembly, and the judiciary, that's the courts, shall be forever separate and distinct. Well, they're trying to break through that separation of powers.
If you're a Republican voter or a Democratic voter, should you see it in Republican and Democratic terms, Governor Easley? What's the right call here if you're a civically minded person casting a ballot?
Well, you know, campaigns are fun, and arguing between Republicans and Democrats, it has its place, but then there's time to govern. And the most important thing about this is that the legislature, regardless of which party it is, should not have that much control over another branch, a judicial branch. You already have the legislature setting salaries, setting the terms. They can reduce the number of judges and have on the Court of Appeals. They can increase the number when they want to. They can gerrymander and put these judges in districts where they have to run against each other. That's pretty potent stuff. But you put in addition to that we appoint you and we decide who gets it. That's more like an employer-employee relationship where I hire you, I pay you, I set your hours, and who you're going to listen to when my bills come up there. And that's just too much leverage. It's not a co-equal branch, and we don't have the independence that North Carolina has had for so long for their judges in the judicial system.
But you do have the division between the parties, because in this case, it was legislators of my party that are in the majority now who submitted these two proposals. And so the Republican Party feels like that is the party organization, feels like they've got to support all of the 6 amendments, that is 4 that we might disagree on amongst us governors. But these last 2, the Republicans are saying they want those passed too. The Democratic Party is saying no. But think, this is not about one party, because just as the pendulum swung from Democratic majorities to Republican majorities, that pendulum can swing back. People are looking now at the possibility of a blue wave having a major effect. Well, it can do that, and so that's why I say they need to be very careful and not put something like this in the Constitution, because it can hurt both ways.
And we'll sum it up right there. Folks, you've heard the pros and the cons on the Judicial Appointments proposed constitutional amendment. It will be on your North Carolina ballot if you cast one this fall. Thank you so much for watching this as our partnership with the North Carolina Bar Association. That group wants you informed on the choices you're going to make that could affect our state constitution. I'm Kelly McCullen. Thank you so much for watching.
Amendments Explained is a production of UNC-TV in association with the North Carolina Bar Association and the North Carolina Bar Association Foundation.